We're here to discuss a few matters, most prominently and importantly, two cases that we wanted to advise you about. I'm going to start with a wage theft case. The arraignment just took place today, and I'm joined by members of our great investigation division, the team that worked on this matter. Rosalind Pathak, the head of our worker protection unit, Deanna Corbett, coordinator for the unit, and Alala Hickson, who's a paralegal in that unit. You should be familiar with the work. This is the latest in a string of important cases in this area, part of our ongoing mission to protect hardworking New Yorkers, including some of our most vulnerable neighbors. KFP Construction and its owner, Candace Paul, have been indicted for allegedly stealing $67,000 in wages from 10 Spanish-speaking workers who we hired to do drywall plaster work right here in Manhattan on the Upper West Side. The allegations follow a painfully similar playbook, similar to many of our wage theft prosecutions. Issue a paycheck that bounces, refuse to pay overtime, and sometimes refuse flat out to pay workers altogether. Those are some of the allegations here. In Manhattan, we value our workers, and here at the DA's office, our pledge is to fight to make sure they receive every dollar that they earn. We know that what may seem to some like a relatively low dollar amount is for those making minimum wage, or for those who, as we allege, are unlawfully not even paid that minimum wage. This amount of money can have life-altering consequences. Wanted to draw your attention again to a similar pattern we've seen in other cases. For example, our case charging two Grimaldi's owners and managers. We saw text messages that we allege literally laid out the scheme. So you see them sort of arrayed on either side of you here. You tell me the same story many times from morning to morning. I want my payment. I mean, when are you going to pay us? A text from a worker to an employer. Here, you told me that the check would have funds. It is 5 weeks that I've not collected. Is not fair. I need the money, please. You see a number all around. You'll see one in particular about payment for food. I don't see it right now, but you'll see just the need that is laid out here, right here. Let me know when you can pay me. I'm out of food and I haven't been able to pay my rent. I know it's not your fault, but you owe me money and you have to pay me. And indeed, that's why we are here, because we allege the law required such payments. And as a result of this and other evidence, we allege, that was put before a New York grand jury, Paul and his company are now charged with scheme to defraud in the first degree, a Class E felony, and grand larceny in the second degree, a Class C felony. The grand larceny charge is particularly noteworthy. It's a recent change in the law that we advocated for in concert with our legislative partners. We are now able to charge wage theft for what it is, the crime that it is, which is larceny. Some workers deserve to be compensated fairly for their wages that they earn. Our investigation is ongoing into this conduct, and we encourage any other KEP employees, and in fact, any employees who have been exploited, to report wage theft to our office. The number is 646-712-0298. Again, 646-712-0298. I wanted to also advise you on a case that we announced yesterday. You'll see the through line really is exploitation of some of our most vulnerable populations here, including low-income and immigrant New Yorkers. The case that I'm referring to secondly, our sex crimes prosecution of Augustin Diaz, who we allege targeted immigrant women who were in desperate need of work. We allege that Diaz repeatedly approached Spanish-speaking women on the subway and asked them if they were in the United States and needed employment. He, we allege, lured them to isolated locations with promises of jobs and then sexually assaulted them in a pattern he repeated with at least 4 survivors. On at least 2 occasions, we allege, he threatened to have the victims deported if they reported what he did. After his arrest for the most recent alleged incident, our great intimate partner, Sexual Violence Bureau, launched an investigation and uncovered additional alleged crimes based on the pattern that we allege, which spans back to 2018. We believe that there may be more victims, and so again, I'm asking for anyone who has knowledge of this conduct or who may indeed be a survivor to reach out to us regardless of immigration status, and the number to call for this matter is 212-335-9373. Just wanted to touch quickly on 2 other non-case related topics. The first is the issue of discovery. I know we've had a lot of discussion over the last couple of days about changes to the discovery law. This is something that at the Manhattan District Attorney's Office we've been talking about and advocating for a change in Albany for at least the last 2 sessions. Our top priority is public safety, and we believe that reforms to the discovery statute would advance public safety. Very happy to hear our great partner, the police commissioner, talk about this in her briefing on the end of the year crime stats. As you know, crime is trending down in New York City and being driven in large part by the decline in Manhattan. But we have a lot more work to do. And in particular, we've seen with our misdemeanor docket, dismissals due to discovery. We've seen a 40% increase in misdemeanor dismissals citywide since 2020. Changes to the statute would address that, and many of these cases are the kind of cases that have been flagged for recidivism concerns. Let me just give you one example of the way the statute operates in a way that we believe is inconsistent with public safety. The statute requires disclosure of evidence by the people, by the prosecution to the defense within a short time frame, and if that evidence or discovery is not disclosed within that time frame, even if it's inadvertently withheld, some judges are dismissing the cases. So for an example, an actual case example, a domestic violence case in which we belatedly but in good faith discovered pictures of a survivor's injuries, so proof that helped our case, inculpatory evidence. We located it, turned it over. So judge, we will not use this photo that shows the injuries that we allege happened. The defense has a purpose for them. We have no objection. Just tell us we can't use the case and let's go forward. The judge interpreted the discovery statute as requiring dismissal of the case. We see that over and over and over again. And when I give you that statistic of a 40% increase in dismissals citywide, multiply that example literally times hundreds. So that is something we need to fix by statute, and it will go a long way to helping with the recidivism we're seeing and will advance public safety. Finally, one last topic. It's not why we are here today, but I know a number of you have asked our communications folks about it, so I will address it. As I think you all know, on May 30th, 2024, a jury of 12 New Yorkers returned a unanimous verdict of guilty in the case of People v. Trump. As you probably also know, Justice of the New York State Supreme Court has scheduled sentencing for tomorrow morning at 9:30 a.m. We have been in litigation throughout the week. We're encouraged by a decision by both the Intermediate Court in New York for our appellates, the First Department, and also by the New York Court of Appeals, continuing the scheduled sentencing for tomorrow at 9:30. The matter is now before the United States Supreme Court, and we will await that ruling. As of right now, sentencing remains scheduled for 9:30 in the morning, with the defendant scheduled to appear virtually.